put my sweat, my mind, my everything into it every day, and I'm being required within the vacation to delegate somebody to go and do that case for me from my firm, I'll not be happy because they will not know the case as much as I know it, which, brings up a problem. So we know one thing. Historically, the reality is that the recess is meant for the judges. So the vacation period is meant for the judges. They used to come from England to Ghana, and so they would sit for all those 10 months and then take the 2 months, go back home and rest, and then if they have any backlogs, they take care of. So the legal vacation was originally conceived primarily as a necessary rest period for the bench. That's judges. A formal pause, it was meant to clear backlogs, conduct research, and research. Over generations, the bar naturally aligned firm schedules and leave with this statutory judicial law. Designated vacation judges carry a heavy double burden, hearing urgent emergency applications for colleagues on recess while managing their own case dockets. This creates administrative tension between judicial discretion and rigid court schedules. Vacation judges take their own earned leave when the new legal term officially opens in October. So all the judges who are doing cases now, when we return in October and all judges return, they will also now begin their leave. Now, there's a risk of protracted delay for those lawyers who are saying they don't want to do their cases during the vacation. If a vacation judge refrains from taking substantive matters during the recess, untaken cases may remain frozen until the following term. So, whilst it doesn't make sense for any law firm to say that they will take their own leave within the 10 months period, because the course will go on vacation in August and September. So if August and September, the judges will be on vacation, a law firm, it doesn't make any logic for a law firm to schedule their leave period before this period. So naturally, this is what has happened over the years. But what must be stated is that it is a matter of fact. Every vacation period, there are vacation judges. And the vacation judges, they have their own cases in their courts. And they deal with them like they would have dealt with during the normal period. So it is not correct to suggest that they have been selected, these judges have been selected to do particular cases on an ambulance manner, to achieve whatever aim. It's an unfair criticism of the system. Except I will say, as a matter of fact, that even though vacation judges will hear their own substantive cases during the vacation, often if a lawyer goes and pleads with them that they don't want to do a case in the vacation because they also have vacation, they want to rest, or they want to attend various engagements they have arranged during the period, the judges will normally grant them that opportunity to go. But the danger is that once you are granted the opportunity and August, September is not used to do your substantive case before the vacation judge. In October, the vacation judge also goes on leave. And when they go on leave, their cases too will be handled by other judges. But the other judges who take over their cases cannot handle their substantive cases. Whilst the vacation judges are sitting now, they cannot handle substantive cases of the other judges cases that they have taken. So you can have a judge in, say, Commercial Court 1, who is a vacation judge, and that vacation judge will also hold brief for Commercial Court 2, 3, 4, and 5. So all cases in those other courts will go on during the vacation, but only applications, emergency matters, but not the substantive case itself. When you are doing a case itself, sometimes there are little what we call interlocutory processes that come on. So for example, you file a case, but the case you have filed, the other party is doing something you want to stop them from doing, you need to file an application for injunction. That is an interlocutory matter. The vacation judge who is holding brief for another judge can hear that application, but not the main case to deliver judgment. They'll wait for the judge who has gone on leave to come and hear the main case. Then when it's in October, we resume. By the second week, that judge who is on vacation also now, who was doing the vacation court, also now goes on vacation, and all the other judges in the Superior Court, they return. When they return, those that judge was holding brief for, they will take that vacation judge's court cases as well. But they too cannot hear the substantive case. They will hear only applications and minor, stuff like that. What that means is that that particular judge would have had about 4 months of their case not being heard if what these lawyers are asking for is granted. It means their cases will not be heard until the next year, because the legal will go into December, and that will be the implication. So please stop the unnecessary insinuations that the vacation court is a new thing and is intended to do something untoward. But I will advocate that the courts, they bring the vacation judges rosters or vacation court rosters, they bring it early enough. Well, this year they brought it a bit early. They brought it by June. So from June, some of us were aware of the courts that will be vacation courts. But sometimes by that time, you have already arranged your international engagements, among other things. If they bring the courts that are supposed to be on vacation by the start of the legal term, that is in October. So we know that in the 10 months that we are going to be doing cases, we know that when it gets to July, in August and September, a particular court will be a vacation court. Then you can arrange your leave not to coincide with the vacation, which is for the judges. I'm sure if that is done, it will be helpful to us. Thank you very much. That was by way of the Law 101. I'm sure that I have overdone the time for the Law 101. Let's try a quick recap of what we did last week on the Sedina case, as has been heard and determined by the Court of Appeal. And then we'll go to the Akonta Mining 1, which is what is pending. And after we are done with the Akonta Mining 1, I will now get to allow you to call in and to ask questions on both cases. Last week we did the Sedina. So by recap, remember that we had indicated that the Sedina case, Sedina was the CEO of Maslock between 2013 and 2017. And she faced 78 criminal charges together with the operations manager of the Maslock. And they got convicted by the High Court in April 2024 and sentenced to 10 years imprisonment. And then her operations manager got 5 years imprisonment. The matter came to the Court of Appeal, and the Court of Appeal overturned the conviction on the 30th of July 2026, the conviction for Sedina. The operations manager, Daniel Axim, also has an appeal which is pending. That has not been finished yet. It's Sedina's own that has finished. We understand that she filed the appeal in 2024 in May, soon after she was convicted, but she was out of the country. She had run away. She had asked for permission to go for treatment. In July, the 30th of July, a day before the court will go on break, she asked for permission. She got her passport, which had been detained as part of her bail conditions. She got it, and then she went out, never came again, and it took about 2 years before the court continued with the matter. So what was alleged? Major financial irregularities, more than 25 million in direct losses were attributed to her as losses that she caused while she was there. And we showed you some of the buses and cars that she procured and the problems that came with all of that. Over 61 million Ghana cedis in unauthorized procurement obligations. That refers to the cars that we spoke about, 350 vehicles that she supervised the purchase by way of a contract. Diversion of relief funds, irregular procurement of vehicles and phones. Diversion of relief funds. There was money that was supposed to be given to market women who suffered a fire situation in Cantamanto. It was alleged that that money did not exactly go, 1.5 million, did not exactly go to the people, but only a fraction of it, about 1,500 or so, was only disbursed. And there was also another fund for setting, financial literacy, 1.8 million, financial literacy across the country for MASLOC beneficiaries. That was also alleged that only a fraction of it was actually used. I think that was the one that was said that only a small amount of it was actually used. Irregular procurement of vehicles and phones. There were phones that were procured, and the amounts of the cost of the phones were alleged to be badly inflated. Improper payments to herself and her deputy, right? Ex gratia that they took in lieu of, and then leave entitlements. You know, they had leaves to take. They didn't take the leave when they were in office. So when in 2017 there was a change of government and they knew that they were going out, they then got the payments that they felt they were deserving because they were supposed to have gone on leave. They didn't go on leave, so they were entitled to the money. And questions were raised about that. So she got 10-year sentence, convicted on multiple economic offenses, 132,000 total fines. Apart from the custodial terms, she got financial fines of 132,000, which if she didn't pay, she was going to get additional terms in jail. Daniel Axin got 5 years imprisonment, and the trial proceeded in absentia because she failed to return from a medical treatment abroad. And then the Court of Appeal found that 34 of the charges on which she was convicted were defective because they were not detailed. They didn't carry sufficient particulars. 20 charges of willfully causing financial loss, 11 charges of conspiracy, 3 charges of causing loss to public property. All of these were said to not have been proven beyond reasonable doubt. If you go to court over a criminal case, you must prove beyond reasonable doubt. The Attorney General, as is said in the case by the Court of Appeal, did not prove beyond reasonable doubt. That's how she got her freedom. The case in criminal prosecutions is that the prosecution must prove your guilt beyond reasonable doubt. If there is a small doubt that arises that you are able to raise in the process, it goes to your benefit, rather to acquit you than to get you in jail. The burden generally rests on the state throughout the trial. Silence cannot be used to fill gaps in the prosecution's case, because the Court of Appeal has said that because she had run away and she was not around, the trial court kept saying that if she were around, she would raise reasonable doubt through some of the things that had been said against her. But because she was not around, she didn't afford herself that opportunity, right? Then the Court of Appeal said, no, silence cannot be used to fill gaps. There were times the court felt the burden, could be shifted, the burden of proof could be shifted. And the Court of Appeal said, unless the law itself has said that the burden of proving the innocence is on the accused, you don't shift the burden. It must always be on the prosecution to prove beyond reasonable doubts. They refer to Article 1910 of the Constitution. An accused person cannot be compelled to give evidence. They can come to court and keep quiet throughout. The accused has a choice whether to testify or not. So if she didn't show up and didn't say anything apart from the statement she gave to the police, which was used, or she gave to Iyoko, which was used. She was not under obligation to say anything else. The court identified major evidentiary gaps. There were WhatsApp messages allegedly relied on were not produced. There were claims that by the microfinance company where the first charge came from, that, that 500,000 Ghana cedis, which they intended to invest in the microfinance company, and because they demanded 24% interest, and the microfinance company in Ejura, in Ashanti region, the Obatampa company said they couldn't pay that much of interest. And because they couldn't pay that much of interest, she asked that the money be brought back, and then they returned the money. She had issued an ADB check to pay for those, for that, investment. They were bringing back a check. She rejected the check and said they should bring cash. They should bring cash. And they brought cash in a Ghana must go back to Bachona Total filling station, and she received it. That's the claim there. And then when she received it, instead of giving a receipt, there was a back and forth about that. As you may have followed the story so far, that's the prosecution's case, that in that course, the people claimed that there were WhatsApp exchanges. The Court of Appeal said, you didn't bring the WhatsApp exchanges in the court. If you claim there were WhatsApp exchanges, you didn't bring them. Some documents were not properly authenticated. Key witnesses were not called. Yes, the market fire, the people who receive the money, if you say they didn't receive the relief funds, why don't you call them as witnesses? You didn't call them. That weakens your case. The financial literacy training, that cost 1.8 million. You didn't call the people to testify whether they were trained or not and they received the money. You didn't do all of that. You only relied on an audit report and Iyoko's statement. That was not fair. All right, so as I have said this already, that's what has happened. And so eventually that's what the situation was. So this is just by way of a recap of what happened last week. Thank you very much. Now going to go to the Akonta mining and that judgment that was also delivered, that a lot of discussions have come up. So 6 charges were brought against Bernard Entwi-Boesiako alias Chairman Wontumi. Akonta Mining Company Limited was also charged, a company that he owns. And then there was one gentleman by name Kwabena Entwi was also charged. He and that gentleman are the two people, Kwame Entwi, not Kwabena Entwi, Chairman Wontumi and Kwame Entwi, or Bernard Entwi-Boesiako and Kwame Entwi. The first accused and the third accused, they together formed Akonta Mining, which is the second accused. They together formed Akonta Mining Company Limited. Akonta Mining Company Limited. So they had 6 charges against them. What did the charges center on? 3 of the charges, counts 1, 2, and 3, were on assignment of mineral rights without approval, and counts 4, 5, and 6 were on facilitating an unlicensed mining operation. The first 3 counts, it's simply that he got a concession lawfully. The state gave him a concession to do mining, legal mining, but he gave somebody the opportunity to go onto the land, the concession to do something else. The law they used in court, the Minerals Act, Mining and Minerals Act, is to the effect that when you get a concession, it's exclusively yours. To let somebody come onto that property, you must come back to the Minister for Environment, Lands and Environment, to give you a license to be able to give somebody the opportunity to go on the land. But he gave somebody the opportunity to go on the land to do an activity without the proper prior approval of the state. facilitating an unlicensed mining operation. That's simply that the person was on and he gave the person the support to do what he had to do. It was in Samraboy, and on the 16th of April 2025, that police officers went to Samraboy to do an anti-galamsey operation. And when they went there, they arrested one gentleman by name Jedu AC, together with 28 other workers, and they seized 25 excavators, serviceable excavators. They seized 4 non-serviceable excavators, 8 pump-action guns, 1 single-barrel gun, and 330 cartridges, and then a cash amount of 157,000. Then they also seized gold, vehicles, about 4 of them, motorcycles, and other equipment. The place where they seized them, these people were within a premises or a structure that had Akonta Mining Limited boldly, inscribed on the structure. So the person who was arrested, the Michael Jedu Aisi, who was arrested together with the 28 others for doing galamsey on the land. Michael was questioned by law enforcement, and Michael pointed to Henry Okum and said Henry Okum is his employer. It's Henry Okum who has asked him to do the work. So he's supervising those 28 employees for Henry Okum. Then Henry Okum was picked up by the police. He said he had an oral agreement with Chairman Wontumi to be there to do mining and to do reclamation. There was a portion of the land that was not mined. So he was supposed to mine that unmined portion, and then the portion that has been mined, he was supposed to do reclamation using proceeds from the mining he was doing on that land. Right. The court found that and rejected the defense put up by Akonta Mining and Chairman Wontumi that Henry Okum was doing reclamation. The court found that Henry Okum was a licensed small-scale miner and not a reclamation specialist. Evidence also showed reclamation was expensive. There was somebody from Minerals Commission that Chairman Wontumi called to testify, and the person testified that reclamation is very expensive. And it was found that, and Chairman Wontumi himself admitted that he provided no money for reclamation. So the court said, since you didn't provide money for reclamation is expensive to do, then Henry Okum's testimony that you ask him to mine the unmined portion and use the proceeds of that to do the reclamation is true. Court concluded that gold from the concession was expected to finance the reclamation. That's what I just said. Akonta Mining had not obtained approval to assign or transfer its mineral rights. The concession to him is exclusive. He shouldn't give it to anybody. The law doesn't allow it. To permit somebody to come on, you must get a certain license. And even reclamation, you need a certain registration. According to the regulations, this was not also procured. Henry Okum was also not registered as a licensed or licensed as a mining support service provider, right? So eventually, that's what happened. He got convicted and sentenced to 20 years in prison. He was found guilty on count 1, assignment of mineral rights without approval, guilty on count 4, purposely facilitating an unlicensed mining operation. He had attempted to say that, well, it was the company, Akonta Mining, that dealt with Henry Okum. So it's not him as an individual. and the court found that Akonta mining is the same as Chairman Wontumi. Chairman Wontumi is the same as Akonta mining. There were no corporate governance, everything, and there were testimonies that everything Akonta mining was Chairman Wontumi who did everything by oral arrangement. So he was sentenced to 20 years imprisonment on each count, and the sentences are to run concurrently. I gave you education about that yesterday. If they are to run concurrently, it doesn't mean that you serve 120 and come and serve another 20. You serve 20 years and you are gone. He was to pay 20,000 sentence to another 20,000 penalty units, which is in CD terms 240,000. But he got these in similar bits, including Akonta mining also got some of that kind of penalties, and all put together was about 600,000 that he was supposed to pay. And if he didn't pay that, he defaulted in paying that, he was going to go to jail, spend an extra 3 years in jail. Right. So that will be it for the Akonta mining as well. In the next 15, 20 minutes, we can have a conversation. If you ask questions, I may be able to give you a further explanation about what happened in Akonta mining. So plainly speaking, this is what happened. He was found or caught doing what he should not have done without prior state approval. And he was also found to have helped the Henry Okum to get excavators from a supplier of excavators who always supplied excavators to Akonta mining to take to Samra Boy to do what? In allegedly to do reclamation. And the argument has been made that reclamation is not done with excavators, purely speaking. They are not done with excavators. They're done with some other heavy machine and not excavators. So it is clear that what was intended was galamsey. And then at one point, the Henry Okum, trying to mine the unmined portion, had difficulties. And guess what? There was a letter written by Chairman Wontumi on Akonta mining letterhead to the Western Regional Security. Every region has what you call the regional security, and districts have the district security. We went to the regional security, and they provided protection for what was going on there. He was asked if he knew about what was going on, and said no, he didn't know, he never went there, so he didn't know that they were doing illegal mining. The Kwame entry, the question is, where is he? The court asked him, where is Kwame entry? The two of you own Akonta mining. His answer was that sometime in 2021, he said that he was going to travel. And since then, he hasn't seen him. So he was at large. The lines have been open as we always do. You can call in now and raise your questions. And if you want to make a quick contribution, you have a minute to do so. Let's hear you now. You can join. This is the law. It's your legal light. It is your health law. Right. So whilst I wait for your calls, it's important to also mention that there's something also that the court find. That in the Akonta mining case, there were issues that were raised against Akonta mining, which required Akonta mining to lead evidence to prove otherwise. But Chairman Wontumi and his lawyers, the judgment said, did nothing. They did nothing about it. Hello, Kofi, where are you calling from?
I'm calling from Ho.
Yes, Kofi, let's hear you.
Yes, honestly speaking.
I can't hear Kofi. Yes, Kofi, start.
Can you hear me?
Yes, I can hear you. Go on.
Okay. If you follow the case very critically, you realize that Akonta money, to me, is not telling the truth. So So Akonta Mani wants me to understand or to believe that the man in question, who is supposed to be doing the reclamation, has no other fertile land to plant coconut tree than a reclamation land, which is going to cost a lot of money. Okay? So all the land in Ghana, the man is not interested in any other land than only that land. Oh, come on.
That's why the court said. That's why the court said that testimony was not believable.
I mean, honest to ourselves. So if I listen to this, it doesn't make sense to me, to be honest with you.
All right. Thank you very much, Kofi. So it's part of the reason the court said it didn't believe what Akonta Mining was saying, or Chairman Wuntimi was saying. Hello, Soa, you're calling from where? Oh, did I lose Soa? Okay, who's next on? I can hear that somebody is in the background. I lost Soa. Soa, call us back. I understand the line is quite, normally we have just one line for this, and so sometimes it's difficult to get through, but you try. If you do, let's hear what you have to say about it. Whether you believe that this is a fair thing to have happened to him. And people have asked a question about the sentence. Why 20 years? Couldn't he have gotten less? Well, he couldn't have gotten more, less than, he's got 20. The law says it used to be 5 years minimum. At some time it was even 3 or so maximum, and it was 5 years maximum. And then at a point, we elevated the sentence to 25 years. That's what we should be saying, 25 years. And so, which is the... Hello, Kweku.
Hello.
Yes, let's hear you, Kweku.
Again.
It's you again. Hello, Kweku.
Yeah.
Go ahead.
Yeah, I am saying that from before the submissions made by whoever, the host of the program. Before then, I thought the judgment on these 3 major issues had political strings attached to it. But from what I heard from him this afternoon, I believe these are purely legal issues. Those convicted were convicted on purely legal realm, and then those appeals that were squashed. I think it was also fall within the realm of legality. So what I want to say is I think our politicians would do us a great favor if they should, alienate politics from legal issues. Because from what is going on, I think that's been thrown into our eyes. We thank the host of the program so much for writing us on some of these issues. These are legal issues, I believe. Those who were jailed should be jailed, and then those who have been pardoned at the appeal squash, I think they fall within the realm of legalities from what the explanation given by the host of the program. Thank you, God bless.
Thank you very much, Kweku. Understand who is next? Alpha. Good afternoon. What's your name?
Hello, this is Asa and I'm calling from Bolga.
All right, go ahead. Let's hear you. Okay.
Yes. I have, yes.
Toy, go on and speak. We are listening.
Okay. I have an issue with even how the whole case went. Why couldn't Akonta Mining also have those people who were working on the mine as the staff? Why didn't they use that as a defense? Because if Akonta Mining got the license to mine and he has his staff working there, why should it be a case?
Okay. Thanks for your point of view. Yes, Cosmos, you are calling us from who?
Yes, good afternoon.
Yes, Cosmos, go on.
Yeah, please, I want to ask that does land reclamation need excavator? And then my second question is, does land reclamation need security protection before you can do it? Thank you.
All right, so I suppose the judge asked all of these questions, and that's the reason, part of the reason the judge said he didn't believe and trust what Akonta Mining was saying to be, and Chairman Wontumi was saying to be true. I was talking about the sentencing, and some people said that he could have gotten less instead of 20 years. So it used to be a maximum of 5 years, and in 2019, was it 2020, thereabout, President Akufo-Addo ensured that when, he declared, put his presidency on the line and made sure that we needed to punish this kind of offense, the law was amended, and now the minimum jail term you get is 15 years, and the maximum is 25 years. So he got 20 years. He could have gotten up to 25 years, but he got 20 years. Who is next on the line?
Yeah, my name is David.
David from Sogakope. Let's hear you, David.
Yeah. Samson, we were told that during the trial, there was somebody who admitted that they have done galamsey. No, he was the same person who testified that Chairman Wontumi had indeed involved in the galamsey activity. So my question is, where is the person who admitted that there was a galamsey activity of the land? That person is rather not convicted. So with you, we know we can get some.
So this is the explanation. This explanation to that. Henry Okum.
Yes.
Henry Okum, who got into a contract with Akonta Mining and Chairman Wontumi to go onto the land for, according to Chairman Wontumi, reclamation. But according to Henry Okum, he was to do mining and use the money from the mining to do reclamation. That's Henry Okum. He by law did something wrong because he's a small-scale miner. He's not someone who does reclamation, and he didn't have the license for reclamation. But the reason he was left go and he has not been prosecuted is that he did a plea bargain with the state. You have heard about plea bargain, right? So he entered into a plea agreement with the state where the law allows that you can use a small fish to catch the big fishes. That's how it is done. So he went into an arrangement where he was not put before trial. Originally, you will see that he was also one of those who was arrested and was supposed to be dealt with as, an accused person. But they went to the Attorney General and said, we beg, we can give you ABCD information. You can use us as witnesses. And the state used them as witnesses. There are two of them, Henry and Michael, right? All right.
Okay.
David, you are calling from Kumasi. Let's hear you. Hello, David. Okay, we lost David. Hello, Emmanuel.
Hello.
Yes, Emmanuel, go ahead.
Good afternoon.
Good afternoon.
Good afternoon.
Emmanuel, go ahead.
Okay, thank you very much for this insightful education. I think if you look at Chairman Wontumi, he has dig his own grave because the Akonta Mining was running on his shoulders, not an administrative way. And I have a question about the other guy that he has asked to produce, Kwame Entry. I don't think there is anybody around called Kwame Entry. That person is part of the governance of. I think Dr. Chairman Wontumi has the name is Kwame Entry, and then he has used that name as the same person. Meanwhile, he is the same Bernard Nchibu running the same Akonta Mining. And then you ask somebody to go and man portion of the land before he can use that proceed to do the reclamation. And then you did it on your own without consulting the authority that's supposed to go through the mining process of the guy that you transfer the contract.
All right.
So I think he has dig his own grave. The law is rightful.
Okay, thank you very much. When he was asked, Chairman Wontumi was asked about the whereabouts of his co-director, the one that he owns the company Akonta Mining with, Kwame Enchi, who is the second accused. He's the second accused, A2. When he was asked about his whereabouts, he said that he has been missing since 2021, 2022, because he had told him that he was going to travel somewhere and he hasn't heard about him since. That's why he was not part of the case throughout. So you see that in the case, he is labeled as Kwame Enchi at large. Who else is on? Hello, Angelo.
Something good.
Good afternoon, Angelo. Go ahead.
Please, through the 39 documents, the state prosecutor has very good job, and the lawyer, the judge, has law and the post. I don't know which other law I will use.
You need to reposition yourself. I didn't hear anything you said. You asked a question requiring an answer response, but I didn't hear anything you said. Clement, you're calling from Tema.
Yeah, no, I'm calling from Tamale.
Okay, Tamale. Clement, go ahead.
Yeah, I want to ask. So the appeal court is saying that in a certain case, they still didn't lose any money.
That's not what the court is saying. The court is simply saying that 34 of the charges were defective, and so they've been struck off, which means they have not determined the merits of those 34 charges. The rest of the charges, the state should have proved beyond reasonable doubt. The state didn't prove beyond reasonable doubt. That's why she's been set free. That's all the Court of Appeal has said. The Court of Appeal has not said any other thing. Thank you very much. Well, the state is appealing that case. Hi, Matt. You're calling from Tema.
Yes.
Go ahead.
Yes, Samson. So I would want to agree with the judgment when the judge suggested that the lawyer of Chairman Wontumi, left a whole lot of questions of the answer. I think the lawyer of Chairman Wontumi, lawyer and the appeal did not help Chairman Wontumi. Samson, Chairman Wontumi was tried on a national issue such as Galante. I heard the lawyer of Chairman Wontumi on TV saying that placing the corporate bill applies only to civil cases. And so, Samson, if you are being defended by a lawyer who believes that the listing of corporate bill will not apply to because you are dealing with a criminal case. Meanwhile, all these principles have been established in judicial precedences that have actually been decided on. Solomon versus Solomon, Monk versus Kuma, Abinton versus the West African.
Yeah, the judge used all of those.
Yes, all these things have been established. You see that when the company is set up as an alter ego, when the company is engaged in ultra
because in all his dealings, so according to the witnesses, in all the dealings of Akonta Mining, it is Chairman Wontumi who was doing it. And there was no paper trail. Everything is, oral. That's why they said it's you. Everybody says they know you. They don't know any other person. Yes. And he was asked about when they filed their returns. And there was no evidence of filing company returns as is required annually. When was the last time any board meeting was held? There was nothing like that. So they said, you are the guy. You are the company. The company is you. All right. Sapon, quickly. Yes. Hello, Sapon.
This is Sapon Techiman.
Yes, Sapon, go ahead quickly because our time is up.
Okay. In all this, I pick one lesson for me, which is that the politicians must learn that bitter lesson. Akonta Mining and Wontumi has found himself where he has found himself because he was under the illusion of power and he disregarded due process. Because you could remember the then Minister for Lands and Natural Resources even raised a red flag regarding the activities of Akonta Mining, including that of the Professor something report. It also raised a red flag, but because they were covering up for him, it took the president to even cover up and declare him that at the time he was not engaged in any illegality. So he disregarded those due process because of the illusion of power. And today it's clear. So the other politicians must learn from what has happened to him, the law is right on everything that it has done on him. I even think that the 20 years is too lenient. He should have gone in for the maximum. Because looking at the devastation and the havoc he caused, he should have gone in for the maximum. That's my take.
Interesting there. There were two other cases, but they were civil cases in 2019 and 2023, where companies associated with Akonta Mining or Chairman Wuntumi, who is the owner, were actually found to have been doing some wrong, galamsey or doing mining without permit, where they had permission to do the first thing you call, what is it again? And they went into mining instead of doing the reconnaissance or sort that they were supposed to do, prospecting, or something of the sort, yeah. So two different judgments, 2019, 2023, all found that they were doing something, he and his companies were doing something wrong. But this was a different case. The criminal case was a different case. This had nothing to do with it. All right, so thank you very much for participating in this discussion. This has been The Law. It's your legal light. It is your help law. I hope we had assisted you to appreciate the judgments.
Hello there, you're watching Upfront on the Joy News channel. I am Blessed Suga. If you're not aware of this, perhaps this might be your first historical lecture on reforms that have happened to various constitutions.